Good afternoon. My name is Greg Fletcher, and I apologize for the noise. I'm putting on a headset here. And let me just introduce myself. I have been doing workers' compensation defense for 25 years. I did a couple of years of civil work, but mostly it's been on the defense side in workers' compensation. I started with a large insurance company in-house, worked in Orange County and San Francisco for 6.5 years. Then I started with Bradford Barthel. I've been with them for over 15 years. I worked in the Fresno office and also in the Sacramento office. I'm also the director of our large loss division. We've recently started this division in order to try and come up with new strategies and a different approach for these large loss cases. And this webinar is part of that process, trying to work through how do we handle these cases differently. So with that, we will get started. Catastrophic injuries can be a serious motor vehicle accident, burns or explosions, high falls, traumatic brain injury, failed back post-surgery, amputations, post-traumatic stress syndrome. These are all genuinely catastrophic injuries. And in this presentation, I'm going to distinguish between really two kinds of large loss cases, the genuinely catastrophic cases and those cases that become large loss cases through either neglect or going sideways. We all know those cases. We call them dogs in the industry, and they tend to fill up boxes. They've had multiple attorneys, multiple evaluators, long courses of treatment. In the old days, long periods of temporary disability. And the question becomes, how do we nip that at the bud? How do we prevent a case from getting to that point? And then what do we do when it does get to that point? More in the line of catastrophic injuries, which are genuine. We're seeing drug-resistant infections play a greater part in our cases. Sometimes what would be a normal case or an ordinary case, the injured worker picks up a drug-resistant infection in connection with a surgery, and then suddenly we're more into the catastrophic area. They have repeat hospital visits. They have increasing amounts of pain and become disabled as a result of the drug-resistant infection. And as we know, if they picked it up as a result of our treatment, it is a compensable consequence. The dogs that I was talking about earlier, the problem files, they tend to be characterized by disproportionately bad outcomes when compared to other similar injuries. You can get a case, it starts off, I'll give you an example from my caseload. You bump your elbow on a piece of equipment. We're now 15 years later, after the diagnosis of reflex sympathetic dystrophy and the MSA that came back at $500,000, and the case is yet to settle because of medical treatment issues and because of issues with the MSA. So we see these cases, they start off looking like an ordinary case, and then at some point we start seeing problems, and the case increases in complexity, and there doesn't settle for various reasons. Seemingly impossible to close. These are the cases with very problematic injured workers. Sometimes they're unrepresented. That creates its own problems. Excessive litigation. You tend to find that you're fighting over every little thing and not making progress in the case. So these are red flags for cases that later you might look back and say, well, how did we get here? The physical file fills multiple banker boxes. You sometimes have a problem keeping track of just the file itself. You know, inordinate amount of documents, and sometimes things get lost. That entry in the medical records that would be a smoking gun that indicates that this all happened at home is in a box of medical records that was reviewed at one point, but that was 3 attorneys ago or 3 claims examiners ago. Succession of different attorneys, and not just on the applicant side, but on the defense side as well. Continuity is one of those things that increases focus. You can keep continuity of claims handling, but have a better chance of keeping the case on track with a specific plan of action, and we can focus on the end game, which is resolving the case. Unrepresented applicants often make the claim their full-time job. We've all seen this. I have a number of these files in my caseload. I have a particular injured worker who, no matter what you come up with in terms of trying to get the case moving forward, this injured worker will find a way to prevent that from happening, creating problems, frivolous filings and so forth, and not cooperating. And of course, it's always the defendant's fault. It's always the employer that's trying to destroy their life. But of course, they've become consumed by this litigation. It's almost part of their personality disorder, and that makes closing the file very difficult. Red flags for dogs, something to look for in the beginning of the case. Symptoms grossly out of proportion to the initial accident. Look for that in the medical records. You can see when even the treating doctors are starting to say, gee, I don't know why this person is continuing to complain so much. This toe injury should have healed, and they're continuing to complain of extreme pain and problems in their daily life, and we don't know why. That's a red flag for this case becoming what we call a dog. Multiple body parts alleged as injured when the accepted claim is for a single body part. You know, it starts as the toe injury, then it's the ankle, the knee, the hip, the back, the psyche, the stomach, sexual dysfunction, sleep disorder. These are how injured workers and their attorneys turn what would be an ordinary case into a complex case and, in their mind, increase the value, hopefully. And, of course, we want to be fighting that and corralling the case, keeping it back to what the original injury was. There are psychosocial factors that affect these kinds of claims. Injured workers that have family issues, that have a history of substance abuse or drug-seeking behavior. Is this really all a way for this injured worker to get drugs? And that's why the case keeps going. We do have some tools, and there's increasing focus in the industry and nationally on opiate abuse, and there will be some strategies and perhaps even legislation which will affect the ability of the injured worker to continue to use the workers' comp system to get drugs. Problem employee. Often with these dog cases, you look back at the personnel file and you find that this is an injured worker that was just on the verge of being fired, has a history of disciplinary problems, and then suddenly the claim becomes a way of hanging on either to the job or turning the job into some additional resources. History of mental health problems. It may not be as a result of your injury, but somebody who has a personality disorder, who has anxiety, who is prone to depression, is going to be someone who is less likely to heal, and you're going to have to flag that case and see what you can do. Number one, keeping the mental health issues separate from your workers' comp claim so it doesn't become something you're paying for. But second, understanding how that impacts on your ability to close your file. And we all know there are certain red flag doctors, whether they be treaters or QMEs. The industry has a long history. All of us have experiences with certain doctors who take an ordinary claim and turn it into something that it shouldn't be. And there are notorious treating doctors and notorious AMEs or QMEs, and in the old days, partisan QMEs. Also, red flag attorneys. There are some attorneys that seem to be litigious, that don't seem to understand that it's in their interest to close their file and get their injured worker functional and back to work. And those cases drag on, and those attorneys seem to be litigious and want to fight about things. And it's our job to keep things on track and move the case forward. Regardless of which type of large loss case you're handling, whether it's one that sort of occurs because of the system, because of the red flags we've talked about, or whether it's a genuinely catastrophic case, pick your battles. It's very important to know when to fight and when to try and negotiate with the other side and come to a resolution. Often in these cases that we talk about, you see where things have gone sideways as a result of litigation over issues that really probably should have been resolved. And I'll give you a quote from Sun Tzu from The Art of War. He will win who knows when to fight and when not to fight. And that's very true. Again, take a look at the cost-benefit of litigating or fighting an issue. If there isn't a whole lot at stake, if it's a discovery issue, if it's about turning over some documents, maybe you might want to compromise on that issue. On the other hand, if the other side is not being cooperative and you need to use the board, get to the board quickly, get a decision. The WCAB is not always your enemy. It can be your friend. It can be used to move your case forward. The key is to know when to do that. All right, genuine catastrophic injuries have a high dollar value exposure. They're treated differently, or they should be, because they are. There is so much at stake here. They tend to have greater scrutiny. There are more people involved in the chain of getting authority and in making decisions. The claims administrator, supervisors, claims managers, vice presidents, there are brokers involved. Employers are often interested. There's reinsurance. If the case gets up to a certain point, then suddenly you have reinsurance and they have their own interest, and you may have to start all over in educating the reinsurance adjuster as to the nature of the claim and why it's worth what you think it's worth. You also have unique tools that you use in high exposure or catastrophic claims. Sometimes with medical, we will use a life plan. We, of course, are all familiar with the Medicare set-aside. They can become quite large in these cases. We often are settling by way of a structured settlement, which is something we don't do in the smaller cases. Extra attention is justified in these catastrophic cases because so much is at stake. This justifies investigating a little bit more, doing witness interviews, going to the scene, actually seeing where the injury occurred. This is something you can have your attorney do, you can have an investigator do it, you can interview witnesses over the telephone, but it is worth getting as much in terms of investigation as you can in cases where there's quite a bit at stake and certainly where the facts are in dispute. Surveillance, always justified in cases where the dollar value is quite high. If there's any hint that the injured worker is not functioning at the level they claim, they're functioning at a higher level, it doesn't take much in the way of surveillance in a case where somebody is claiming severe impairment to show that that's not the case. The deposition of applicant, we often take depositions, but we may want to take a different kind of a deposition where we go into greater detail and we really go over a lot more than we ordinarily would in a run-of-the-mill case where we have a catastrophic injury. Depositions of AMEs or QMEs, they're more common in these kinds of cases because, again, their opinion is so crucial to how your case goes, and we don't get the best experts in workers' compensation. So it justifies deposing the AME or the QME that much more because so much is at stake. And often the issues are quite complex, and our experts sometimes aren't really equipped to handle the complexity or the difficulty of the medical issues. Depositions of treating doctors. We ordinarily don't do that in workers' compensation, but in these catastrophic cases, we often have a long history of treatment. Sometimes the treating doctors know more about the condition than the AME or the QME, and sometimes the treating doctor can really shed quite a bit of light on the medical issues, and you can get some very useful information through deposing the treating doctors. The use of experts. We often here at Bradford Barthel hire a doctor to help us with medical issues. We're not doctors. If we think that an advisory opinion would be helpful, we can send the medical record to a doctor to give us an advisory opinion. They're work product. They're not discoverable because the only reports that you have to serve on the other side are reports of evaluating physicians. So since this doctor doesn't evaluate the injured worker, they're just giving us an advisory opinion. We can keep that information, whether it's good or bad, and we can use it in determining where we want the medical issues to go, and whether we want to get additional evaluations. We can use those opinions in preparing for depositions of our AME or QME, and it is very useful. In ordinary cases, watch for red flags and look for opportunities. When reviewing files with lengthy histories, there's always a point where the case could have been resolved for a particular fixed sum, and a decision was made or avoided which resulted in the claim remaining open and ultimately often increasing in value, sometimes exponentially. We all have that experience where we pick up those boxes and we start going through that file that's just been assigned to us, and we see the points at which a different decision could have been made and the file could have been closed, and someone decided not to do it or just missed that opportunity for whatever reason. So we want to be proactive in spotting those opportunities, and one way to do that is to look at our organizations and ask ourselves, is this an organization where we can make decisions based on an open exchange of information? Many of our clients are trying to change their corporate culture to make it easier to identify those points when claims or particular issues can be resolved and to foster an environment which supports seizing those opportunities and getting the case moving or settled, as opposed to picking a fight or drawing a line that later we look at and we decide maybe that was unrealistic. the tension is to fight the issue versus resolve the issue. And of course, if we can resolve it, that's generally the better way to go. Of course, we don't want to spend too much, so that's the tension. At the diagnosis stage, there are a number of red flags. And what I mean by that is there are controversial diagnoses. There are diagnoses that sometimes are thrown about loosely. They're real conditions, but they don't manifest as often as we seem to see them in medical reports and workers' comp. Fibromyalgia, probably the most controversial diagnosis. It is essentially unexplained, non-anatomical pain. Reflex sympathetic dystrophy or complex regional pain syndrome is not as controversial. It is an objective, it is a diagnosis that's recognized, and it has objective findings. Our slide here refers you to a page in the AMA Guides 5th edition that gives you a list of criteria. We don't use the AMA Guides typically in diagnosis, but this is a useful chart that gives you a number of objective factors, and you can ask your doctor, are these factors present or not, and try and really get at the diagnosis. We see these terms thrown about quite loosely. Objective signs of RSD or CRPS, vasomotor changes, skin color mottled or cyanotic, skin temperature cool, edema, pseudomotor changes, which would be skin dry or overly moist, trophic changes, skin texture smooth, non-elastic, soft tissue atrophy, especially in the fingertips, joint stiffness and decreased passive motion, nail changes, blemished, curved, talon-like, hair growth changes, falling out, longer or finer. Objective signs continued, radiographic signs. These would be studies that provide objective signs, x-rays, bone scans, things like that. They can be viewed as consistent with CRPS. The question is, has the doctor making the diagnosis really made any effort to identify these objective signs? If they haven't, if they just say, well, there's extreme pain, and I think there's a chronic pain syndrome here, and I'm going to call it RSD, then really you want to question that diagnosis right from the start and see, is this really RSD, or is this somebody who is having an out-of-proportion subjective response to an injury for whatever reason? Post-traumatic stress disorder is another term that's thrown about quite loosely in workers' comp. It really requires an extreme trauma and, in most cases, fear of death with no escape. Getting yelled at or somebody being mean to you in a meeting at work is not going to produce post-traumatic stress disorder. And when you see that diagnosis from a pure stress claim from someone who claims they've been harassed, really question it. And there may be something going on, but it's probably not PTSD. Traumatic brain injury, this is another term I see thrown about quite loosely. True traumatic brain injury, and there is mild traumatic brain injury and traumatic brain injury, but true traumatic brain injury is beyond post-concussion syndrome. It involves a violent blow to the head or body and even an object penetrating the skull. A diagnosis based on injured workers' subjective description of symptoms like I don't remember as well, and I'm dizzy, and I'm confused, I have headaches, and so forth, loss of balance. That is not necessarily a true diagnosis, and really question that doctor there. Sexual dysfunction and sleep disorder, this is another area where these terms are thrown out without much basis, really. The problem is that to truly diagnose it, you'll need studies or an evaluation by a urologist in the case of sexual dysfunction. And sometimes the evaluation is more expensive than the whole person impairment that's being provided. But ask yourself, is there really an organic basis for this? Most often, the true basis for the allegation of sexual dysfunction and sleep disorder is pain. Waking up from pain, not being able to perform sexually because of pain. That really should be addressed either through the diagnosis for the body part that's in pain or using the pain add-on in AMA Guides. Again, the studies to verify the diagnosis may be problematic. They may be more expensive than the cost of the whole person impairment, so this does create a dilemma for us. Watch for non-industrial comorbidities, high blood pressure, coronary artery disease, diabetes, obesity, a smoking history, alcoholism or substance abuse, mental health history. All those things are, if they're present, are in some cases going to make your case more difficult to resolve. When you get multiple QMEs, you also get into areas where the the whole person impairment can pile up, and we know applicants' attorneys, their new strategy is to ask for as many QMEs as they can. How many is too many? The question is, to what extent do you need a specialized expert, or is the applicant simply using a shotgun approach? There is a regulation, it's 31.7. You can obtain a QME in a different specialty. That's after you've obtained your first QME with a showing of good cause. And good cause is defined as either an agreement by the parties. There's something about an acupuncturist referring the parties to the medical unit. It doesn't apply much. Or when ordered by the WCAB, or in an unrepresented case, you can have an agreement, but you have to have input from the INA officer. Using a single QME is preferred according to the regulation. So your strategy is to pick your specialty, be the first to object, the first to request a QME. QMEs do line up somewhat partisan in our system. The liberal QMEs tend to be chiropractors, PM&R docs, pain management. The conservative QMEs tend to be the orthopedic surgery, to some extent neurology, although not always, and occupational medicine. That's an area we've had great success in our office. If you ask first, and if it's justified by either the specialty of the treating doctor or the nature of the condition, you probably will prevail. Use Regulation 31.7 to get additional QMEs if you think they're needed, or to limit QMEs by requiring the other side to follow the reg, depending on the case. To get an additional QME, show a medical basis for the evaluation and seek either an agreement or an order from the WCAB. To limit QMEs, force the applicant to show a medical basis. I actually was at the board and heard one of our local judges grilling an applicant's counsel on why he needed new QMEs. She kept saying, "What's your medical basis?" And he couldn't answer her because he thought just by putting it in the application that was enough. And unfortunately, for many judges, that does seem to be enough. But with this judge, she actually required a medical basis. So don't assume that won't be a requirement. The question is a mere allegation of an injury on an application enough? The answer is maybe it is. Most judges want to know, is there something here? So at least the QME is going to be ordered. That is unfortunate because that allows applicants' counsel to just throw out a number of alleged impairments and get as many QMEs as they can. All right, we're moving into areas of permanent disability. This is what applicants can do to goose up the permanent disability, to make it greater than it really should be, given the mandate in the statute to use the AMA guides. And of course, we know they use Almaraz-Guzman, they use Ogilvy for loss of earning capacity, and we're going to talk a little bit about Labor Code Section 4662, which deals with permanent total disability. Almaraz-Guzman, as most of you should know, is a case that says that you can rebut the AMA guides rating by showing that the rating is inaccurate, and then using an analogy from another chapter or method in the AMA guides to provide an alternate or rebuttal rating. The elements are, first, the doctor needs to provide the AMA guides rating. They've got to get it right the first time. And if a doctor just jumps in and says, well, I don't think the AMA guides are good enough, I'm going to give you an Almaraz-Guzman, they have not done their job. We need to hold their feet to the fire and get them to provide us with the accurate rating. Then they can tell us whether that's accurate or inaccurate, and I could spend an hour on what I think that means and why I think it's problematic. But think complete. Is it complete? Is it incomplete? If it's incomplete, then the doctor can rate by analogy using the table or method from within the four corners of the AMA guides that they think is appropriate, but they need to explain why this is a proper analogy to the condition they're evaluating. They just tend to have certain knee-jerk responses that go to the station and gait section or the hernia section for standing and walking or lifting, and they do it reflexively without really providing us with much of an analogy as to why that's more accurate. The issue is what is inaccurate, and again, think incomplete. There are cases where it is appropriate. There really is no proper diagnosis or proper rating method in the AMA guide. Inaccurate compared to what? The WCAB and the Court of Appeals have not provided any alternative metric against which the AMA guide's rating can be compared. And I raise a number of questions. Unfortunately, I think the answer to these is all maybe. Can the Almaraz-Guzman rating be an add-on to the AMA guide's rating? We see this all the time. The original case contemplated a replacement rating, not just keep stacking new impairments. But the doctors tend to say, well, they don't. This is not included lifting or standing or whatever impairment they're addressing, and they jump to another section, provide a rating, and then combine or add that to their AMA guides rating to get the result higher. Can an Almaraz-Guzman rating misuse the AMA guides? What if the guides say you can't do something? For example, in Table 17-2 in the lower extremities, there are a number of impairments that cannot be combined. Can the doctor say, well, that's not accurate, I'm going to combine them? The answer is we don't know. Can the doctor add impairments when the AMA guides requires combining? Can the doctor place an injured worker in a DRE category without the objective criteria? I had a doctor once say, well, none of these criteria are present, but they're worse than the lower category, so I'm going to place them in the higher category. The answer is we really don't know whether any of this is proper, but it's possible. The other area I wanted to touch on is this use of a percentage of loss of use. We're seeing this a lot. The doctor takes the total value of a body part and says, well, they've lost 50% of the use of their lumbar spine, so there's a table, it's actually a figure, which shows the total value of the lumbar spine. I'm going to apply 50% to that value, and we're going to end up with, I think, 45% whole person impairment. There are cases that say this is proper, and there are cases that say it's not. My advice is challenge it. I think the doctor is doing a very sloppy job of evaluating. It's not precise at all. What do they mean by 50% loss of use? Is it 50% loss of strength, 50% loss of range of motion, 50% loss of sensation? They don't explain what they mean by that, and in deposition they often sort of fall apart, and you can establish that they really are just taking a stab at it and it's not medically probable, which is our standard. All of the foregoing techniques that doctors use are probably allowed. We don't have a case. We should challenge it. We may end up with some good case law saying at least under what conditions they can do some of these things. And this would be a way to keep the permanent disability from inflating beyond what it should, even though Almaraz-Guzman is being used. The case I want to touch on is Cannon versus the City of Sacramento. This case involved a police officer diagnosed with plantar fasciitis. There were no objective findings and no AMA guides method of evaluation, and that's key. The doctor used the station and gait table to produce a 7% whole person impairment. This was challenged because the City of Sacramento, as I understand it, really felt strongly that there were no objective findings, and that under our new system with no objective findings, there should be no whole person impairment. And they were hoping to establish a precedent to that effect. Unfortunately, they did not succeed, and the Third District Court of Appeals held that, first, extraordinary or complex cases is not the threshold for applying Almaraz-Guzman. In any case where the AMA guide's rating is deemed inaccurate, the Almaraz-Guzman is going to be applicable, and no requirement of objective findings for an Almaraz-Guzman rating. And that's kind of a blow, but we can limit this case to its facts. It is pretty specific. The way to distinguish it is it a medically accepted diagnosis? I mean, the next case is going to be fibromyalgia, but that's not a medically accepted diagnosis. It's controversial. Here, plantar fasciitis, there's no question that this is a proper diagnosis, and it's true that the AMA Guides does not have a method for evaluating for this. So this is a case where Almaraz-Guzman might actually apply. And at the end of the day, 7% using the station and gait section was not the end of the world. It wasn't a huge amount of impairment. Does the AMA Guides provide a method of evaluation? In most of our Almaraz-Guzman cases, it does, and the doctor is saying that's not good enough and wants more. If the whole person impairment is now based largely on overall impact on ADLs, look for overlap. In other words, if the injured worker is saying, oh, my activities of daily living are impacted, I can't walk, I can't lift, and so forth. Back in the old days, in the prior rating schedule, we used to have work limitations, for example, no heavy lifting. If different injuries provided the same work limitation, no heavy lifting, we called that an overlap, and we didn't rate both. I'm suggesting that we might now start looking at these alternative ratings that are based on activities of daily living. Let's look for overlap. Perhaps the multiple impairments that are identified are really resulting in the same impact on activities of daily living, and we can do essentially in reverse what the injured workers are attempting to do. Deflate the rating a bit rather than inflate it. Consider a deposition of your AME or your QME regarding the diagnosis, proper application of the AMA guides, accuracy of the AMA guides, and overlapping whole person impairment. Consider the advisory opinions for expert medical opinions as a way of helping you out, and this is something we touched on earlier. It's not admissible, but it is useful in preparing for a deposition of the AME or QME, and also in sometimes directing the discovery. Your advisory doctor may help you determine what's the best specialty, for example, for a particular condition, and also even issues of medical treatment and where to try and push medical treatment. Often in these large loss cases, we have nurse case managers, and we are attempting to manage a very complex treatment regimen, and sometimes our outside experts can help us with that. All right, moving on to earning capacity. Ogilvy and LeBoeuf are the two cases we're going to talk about. If you recall, our new rating schedule provides an adjustment for earning capacity. It's now been modified with SBE, well, with the newest reforms. And in the old days, we had LeBoeuf, which had to do with vocational rehabilitation. LeBoeuf was a case which held that if an injured worker could not be rehabilitated, then they were 100% permanently and totally disabled. And that meant they were not feasible for vocational rehabilitation. The case has hung around because the new standard is loss of earning capacity, and loss of earning capacity has been equated by the courts as the same thing as loss of the ability to compete in the open labor market, which was the old standard for permanent disability. So the courts have held that even though we don't have vocational rehabilitation anymore, LeBoeuf is alive and well if it can be established that the injured worker has a complete loss of earning capacity. Then they are found to be 100% permanently and totally disabled. There's the site there. Vocational evidence can be used to rebut the diminished earning capacity under the Ogilvy case. Unfortunately, we don't have any real guidance as to how that is to be done. We're all kind of fishing around in the dark with our vocational experts, and we do get the experts, and often the Workers' Compensation Appeals Board is now just taking the percentage of loss of earning capacity that the expert provides and applying that as permanent disability. There's no basis for that in any binding authority that I'm aware of, but it is something that is being done. The original Ogilvy case involved rebutting the schedule using vocational experts, and it went up through the courts and ultimately got to the Court of Appeals, which overturned the formula that the WCAB came up with. And so we don't have a formula for applying the percentage of loss of earning capacity, but the courts continue to hold that rebuttal evidence is admissible to challenge the loss of earning capacity ranking in the rating schedule. And this, as I just said, there's no binding support for just applying the percentage, but it is being done. In LeBoeuf situations, an analysis is required as to how much of this inability to return to work or loss of earning capacity is actually due to the work injury and how much is due to other factors. So again, we have a Labor Code section. Labor Code section 4664A indicates that the employer is only liable for the percentage of permanent disability directly caused by the injury arising out of and occurring in the course of employment. That means you're only responsible for what your employer caused. So look for other factors: lack of education, language barriers, the labor market. If someone can't get a job and they lose earning capacity, maybe that's because we're in a recession. Now, moving on to Labor Code section 4662A. This section provides a conclusive presumption for permanent total disability, and that's not the section I'm going to talk about today, but it provides a conclusive presumption of permanent total disability for loss of sight or loss of both eyes, loss of hands, practically total paralysis, brain injury, resulting in permanent mental incapacity. But here's the key. The bottom section, the last sentence in that statute, provides that in all other cases, permanent total disability shall be determined in accordance with the fact. What does that mean? Well, nobody really knows. We don't have a Court of Appeals case or a Supreme Court case interpreting it, but we have a line of WCAB cases, district level cases, holding that this is something different than the level of disability determined by the rating schedule. The WCAB in recons has found that physicians and now vocational experts can conclude that an injured worker is permanently totally disabled, and if that conclusion is supported by substantial evidence, then it is going to be followed by the WCAB under this code section, Labor Code Section 4662B, quote, in accordance with the fact. Now, I find this to be quite dangerous. I think it allows doctors and vocational experts to provide mere conclusions of permanent total disability. I see no reason why this statute should provide a standard other than the rating schedule or substantial vocational evidence to support a finding of total disability. But I want everyone to be aware that it's out there, and the key is to find out what is the basis. I mean, the conclusion of permanent total disability has to be substantial. A mere conclusion should not be enough, even though it sometimes seems to be. What is the fact? The answer has never been given. The WCAB has held that this is something different than the rating manual, but we don't know how the doctor gets to that point. Now, what I see in a lot of reports is doctors essentially providing vocational opinions. They will say things like, this person will never work again, or no employer will hire this person. Well, I think that's a vocational opinion, not a medical opinion, and I would challenge the doctor if that's how the opinion is framed. It must be substantial evidence. Again, attack the conclusion. Is the medical expert providing a vocational opinion? Use your own expert to attack that opinion if it's vocational, and consider investigation or surveillance to rebut the underlying premise of the loss of capacity. A number of our benefits now are subject to the COLA. This is another area where large loss cases can get quite expensive. In 100% permanent disability cases, the permanent disability paid at the temporary disability rate, and in life pension cases, these are all subject to the COLA if the injury occurred prior to, I think it's 2003. The percentage of the COLA increase is the percentage of increase in the state average weekly wage. In the last 9 years, the increase has varied from 0% to 5.6%. When calculating the present value of a benefit, negotiate the percentage increase that is used for the COLA. I know that the DEU uses 4.5%. This is a little bit technical, but what we're talking about is estimating an increase every year of 4.5% of your life pension or your permanent total disability award, and that's going to get quite expensive where the state average weekly wage is not going up at that rate. Now, moving on, in 100% cases, injured workers' attorneys often argue that there cannot be apportionment, but take a look at the Borman case. 100% finding was based on vocational testimony, and the judge did not apportion, but the Court of Appeal found that the judge should have based apportionment on the medical evidence. The medical evidence showed apportionment to non-industrial factors. The question is, would the injury produce permanent total disability in the absence of other factors? Where does it really count? Those cutoff points, 99% to 100%, 69% to 70%. If you can apportion 2% and get it under that threshold, you've saved a tremendous amount. Now, speaking of apportionment, there are three types: Labor Code Section 4664, 4663, and then Benson apportionment between industrial injuries. When permanent total disability or life pension are at stake, extra investigation or discovery are justified to uncover prior injuries, prior medical treatment, prior awards, in order to establish some apportionment, because it becomes so crucial. Do an index search, take depositions, subpoena records, private investigation. When do you hire an investigator? When there's a lot at stake or when the applicant begs for it. What do I mean by that? They say things in deposition or in their statement like, I never leave my house, I don't do any of my own shopping, I can't even lift 1 pound. Sometimes the surveillance film is valuable because it confirms their allegations when we were suspicious, and it turns out they are as disabled as they claim, and then we can move on to settling the case. So it cuts both ways. But when it becomes very valuable is when the allegations of limitations are quite extreme. Now, I just want to touch on temporary total disability. I know we have caps, but nothing makes a case worth more than an injured worker sitting at home. Even though we cap at 104 weeks, it's more important than ever to limit that period of time off work. The effects of long periods of temporary disability, lack of routine, loss of social contact, deconditioning from work, depression. Nothing turns a routine case into a large loss case like a lengthy period of time off work. The injured worker gets used to not working, thinks of themselves as disabled, not able to do anything. All right, moving on to medical treatment. In catastrophic cases, we have a different order of medical management. We have very complex medical management, and often we will use a nurse case manager or other tools to manage medical care, and in particular to coordinate among multiple treaters. And I urge you in complex cases to hire a nurse case manager. It can save you a tremendous amount of time and resources. But it is also considered medical treatment. So if you try and fire your nurse case manager and the applicant likes the nurse case manager, there is a case out there that says you can't do that. That was found to be a medical benefit which cannot be eliminated unilaterally. So be sure you know your vendors and you know the people you work with. If your nurse case manager is viewed as too partisan by applicant, they can limit contact with the applicant, but they cannot prevent your nurse case manager from talking to the treating physician. They can prevent the nurse case manager from contacting the applicant directly or attending appointments. You might need to develop a life care plan in a catastrophic case. This is a plan which outlines the estimated costs of medical care, much like what we see nowadays in a Medicare set-aside, but this is something that was done before that and involves all the costs, not just the Medicare covered costs. This can help you determine the cost of a case and perhaps settle the case in a structured settlement that funds the life care plan, and these are tools that can be used in these genuinely catastrophic cases. Your case depends on the quality of your vendors. That cannot be overemphasized. If you're relying on a vendor to provide you with Medicare set-aside proposals, structured settlements, the life care plans, medical management, a good team with vendors that you trust, that do a good job for you, will make your life so much easier, and this is something that you and your company need to work with. Now, just touching briefly on Medicare, federal law requires that Medicare's interests be protected, as we know. So many of our cases these days involve Medicare set-asides. And what is that? That is a trust that is, in theory, set up to fund the payments for medical treatment that would ordinarily be covered by Medicare. Why is that important? Because Medicare wants to be sure that when you settle your case, you have paid for the medical treatment that they would be paying for, and that way they don't end up having to provide benefits to somebody as a result of your injury. The statute only requires that Medicare's interests be protected. That has been interpreted a number of ways. Now, the Center for Medicare and Medicaid Services, known as CMS, administers Medicare. They have their own voluntary program for submitting Medicare set-asides, and they have review thresholds. It is just that. It is voluntary. However, there is risk if you do not submit your Medicare set-aside to CMS. They may deem that you did not protect their interest and then come after you for a lien in your case, and sometimes additional damages as well. The references here you can take a look at when you, if you want to go further, when you look at the PowerPoint or when you look it up online. Again, it's a voluntary process, and what we're seeing in our company is quite a bit of variety in how our clients approach Medicare. Some have their own review thresholds, some do not submit MSAs, others submit MSAs even below the review threshold in order to protect themselves. So you all out there have your own set of protocols, and you need to work within those. But just be aware that the requirement to submit the MSA to CMS is not really a requirement. It is voluntary. It is very helpful sometimes in settling your case to have an MSA as long as it isn't too high. In other cases, it is prohibitively high, and it kills our deals. It basically comes in so high that we cannot settle our future medical care because our clients and our principals do not want to fund a settlement that high. Medicare is not bound by your settlement, and they might refuse to pay for medical expenses if you don't submit. CMS will have a priority right against any entity that received a portion of the settlement, and that includes attorneys. Now, we haven't really seen this in workers' comp, and I know as soon as you say that, you'll be the one who gets the nasty letter from Medicare from CMS, or even gets the lien. But we all kind of operate based on custom and practice in this area more than by case law. And again, if you don't submit, you run that risk that Medicare will assert the lien despite your settlement of future medical care. The review thresholds are if the injured worker is eligible for Medicare, settlement in the amount of $25,000 or more needs to be reviewed according to CMS. The MSA needs to be reviewed in order to be approved. If the injured worker is anticipated to be eligible for Medicare within 30 months, but not presently eligible, then the review threshold is a settlement in the amount of $250,000 or more. Now, the MSA can be paid in a lump sum or in the form of a structured settlement. You've all seen these either approvals by CMS or the allocation analyses that the vendors provide. They typically give you a lump sum amount, and then they also characterize the MSA in the form of seed money and annual payments for the life expectancy of the injured worker. The nice thing about the structure is it tells you the payout of your annuity, and you can simply get your structure broker to tell you what the cost of that annuity will be, and you can get considerable savings in structuring the MSA versus paying it out in a lump sum. We had a question that was about a COLA. What is it? Okay. Why don't we do that? The question is, at what point do we negotiate the COLA rate? The point at which you are establishing how to settle your case. If you're settling your case by stipulation, you really can't negotiate the rate because you're going to be paying out annually based on the actual SAW increase. But if you're settling in a lump sum based on a present value, then the question is, how is that present value calculated? And it is calculated using an estimated state average weekly wage increase. And typically, I use the calculators at Work Comp Central. They're very helpful. I would urge everyone to go look at their calculators. But it gives you a percentage increase to put in. And then you also get a credit for the discount. So it's increasing, but it's decreasing because since it's being paid out early, you're getting a credit for the interest you would have earned on that money. It's a little bit complicated. But my point is that the injured worker's attorney may have their own calculation based on 4.5 or even more percentage increase. You can do your calculation based on a lower increase. And if you're upfront and you say, I'm using a lower increase, I've had a number of applicants' attorneys say, look, for doing present value calculations, I will give you a 3.0% or 3.5% increase in the interest of compromise. So it's when you're settling your case and you're figuring out the present value of those things that are subject to the COLA that you negotiate that percentage. Sure, let's have another question really quick. The question is, am I finding that IMR determinations are getting CMS to reduce their determination? And the short answer is no, but I qualify that by saying I have yet to see that filter through. We are seeing the effect of IMR on the cost of medical care in the system, and it's dramatic. I am not seeing a direct correlation with CMS. And typically it's because we don't interact directly with CMS. We interact with our vendor that prepares a proposal, and that's submitted, and CMS either approves it or doesn't approve it. So we have to get a little bit more close to the process before we can see whether CMS is actually going to take into account the fact that IMR may not pay for something. I think it's a great argument, and I'm actually seeing a number of my clients not settle future medical care right now based on the assumption that the MSA is going to be higher than what they would pay, since they will have IMR and CMS might not take that into account. So I think this is something to really watch closely, and we'll see how it goes. All right, moving on. Always consider a structured settlement in a large value case. Typically, it involves a significant upfront payment and then an annuity thereafter for the lifetime or for a fixed period. You can structure your cases any way you want. And what I prefer is to get at least 3 proposals from my structured vendor with different amounts of seed money and structuring over different periods of time. For example, 15 years, 20 years, and maybe even a lifetime. And that provides the injured worker with some options. They don't feel like you're shoving one proposal at them, and they can decide what's best for them. Of course, since you are purchasing an annuity, you are able to realize some savings on the cost of the payout over time, and that would be the whole point of doing the structured settlement. And it also protects the injured worker by guaranteeing income. If they settle by stipulation and something happens to them, their family is not protected. Your payments stop, and that's the end of the payout of permanent disability or life pension. If you purchase an annuity, they have a guaranteed income that can then protect their family. They can assign the payments for the rest of the fixed period. Now, if the payment is for life, then of course it will stop at the end of their life. I recommend creating a win-win proposal in which the carrier realizes savings, but the injured worker also benefits from the payout. In other words, if the value of the settlement is $100,000, if you can get a structured settlement that pays something more than that but costs the carrier less than that, then both parties win, and it's a much easier sell at the Workers' Compensation Appeals Board. If the carrier realizes 100% of the savings and the payout is the exact value of the case, then there really is little incentive for the injured worker to accept the structured settlement. And judges will scrutinize your settlements more if they feel like all the savings are going to the carrier. But if you can point out to the judge and to the injured worker that both parties win here, then you can win over the injured worker and the judge as well and obtain approval of your settlement. All right, in summary, in a typical case, try and take control and move the case forward. Keep your eye on the goal. The goal is settlement or trial, if that's where you're going. Try and control the specialty of the QME and limit evaluations. Get the injured worker back to work and at MMI as quickly as possible. Don't get sidetracked in peripheral fights, but the injured worker or the injured worker's attorney use the Workers' Compensation Appeals Board to move the case forward and resolve interim disputes when needed, but avoid unnecessary litigation. I can't emphasize that enough. We file for hearings all the time, and we're moving the case forward when we do that. It's not unnecessary litigation to get something resolved as opposed to send endless letters back and forth or have somebody who's not cooperating. If you can get that issue resolved and move forward and keep it on track, you've got the case going in a good direction. Keep your eye on the goal of file closure. In a genuinely catastrophic case, rely on your valued partners, the nurse case manager, the life plan preparation, the MSA vendor, the structured settlement broker. If your medical experts are not optimum in those complex and high-value cases, consider advisory opinions from trusted experts to help you keep things on track and really so that you can get a handle on the medical issues and make sure that your experts are doing the job they need to do. And with that, we are done with our presentation. And I'm going to turn you over to Tammy, who's going to give you some more administrative information.
Thank you very much, Greg.